And now, our next speaker is Giovanni Buttarelli, European Data Protection Supervisor. And I would kindly ask you to take not more than 10 minutes, please. You have the floor.
Dear Mr. De Mera, dear Mr. Hague, honourable members of the European and national parliaments, it is indeed my duty, and it is also with great pleasure that I respond to your invitation to this first constituent meeting of the Joint Parliamentary Scrutiny Group. As you all know, the Lisbon Treaty transformed the area of police and judicial cooperation in criminal matters into a main area of the EU law, so subject to the full jurisdiction of the Court of Justice of the EU. It conferred binding legal effects on the Charter of Fundamental Rights. It also provided, under Article 62 of the Treaty on the Functioning of the EU, the legal basis for a stronger EU-wide data protection law in all areas of EU policy, including the field of police and judicial cooperation in criminal matters. My independent institution, the European Data Protection Supervisor, is ready to continue providing a proactive advice and committed to ensuring that Europol's activities, as well as possibly the ones of other police and justice EU agencies such as Eurojust and the European Public Prosecutor Office, are in full compliance with fundamental rights, of which data protection is an essential component. The Europol regulation, as recalled by you, Mr. Diaz de Mera, as LIBE rapporteur, aligns Europol with the requirements of the Lisbon Treaty. It strengthens data protection rights and ensures in particular that each single individual has the right to submit complaints to us, an independent data protection authority, whose decisions are subject to judicial review. And now Europol, as from 1st of May, by a data protection viewpoint, is supervised by the EDPS. Allow me to briefly say very few words on the main differences compared to the previous supervisory regime by data protection viewpoint, performed at that time by the joint supervisory body composed by representatives of national data protection authorities. In addition to fruitful experience in the past, we now have supervision by a truly independent supervisory authority with second enforcement powers, in line with Article 8 of the Charter. And we are finally judicially accountable as well, since our decisions, as said, can be appealed before the Court of Justice. And you may also say that in some way the EDPS is also politically accountable, and this is the reason for which I'm here today. But we are not alone as supervisor. National data protection authorities continue to be closely involved in the particularly within the Cooperation Board, which has been established. We adopted our rules of procedure in the constituent meeting of the 14th of June, and we as EDPS are not only a full-fledged member, but we also are the provider of the Secretariat. And on top of this, to complete this new strong framework for Europol's accountability, the European Parliament, together with the national parliaments, will politically monitor Europol. What is our role as EDPS in this new changing landscape? We are fully aware, first, of the need to strike the right balance between security and privacy, taking into account the specificities of data processing in the police and justice area. So in our viewpoint, the idea of a secure and open Europe can only become a reality if we are able to ensure at least two things: enhanced operational effectiveness in the fight against crime, which has increasingly a cross-border dimension, and second, a protection of fundamental rights and freedoms of individuals. Let me here quote Commissioner Timmermans saying, in two different contexts, Data protection is something we can easily get wrong, but we have to get it right. And then he added, we need to get our data protection regime in order. That's urgent. It's not nice to do, but need to do. In that perspective, we are ready to reinforce safeguards in a practical and modern way in line with the new challenges for law enforcement bodies, and we are keen to open an entirely new chapter on supervision. We are carefully prepare our processes at the DPS, our resources, in order to perform an effective supervision of Europol's operations and also a responsive advice to Europol and to its stakeholder community in setting up the new data protection safeguard required. In that perspective, we have set up a dedicated team on Europol supervision at the DPS, and this team works in full synergy with all other teams at my institution, those working on policy and consultation, the IT and policy sector, with a view to ensure expertise and coherence in all EDPS policy and enforcement actions. And in performing our new role as supervisor, in the last 5 months from the entry into force of the Europol regulation, we have already carried out a range of duties, including hearing and investigative complaints from individuals who consider their personal data to have been mishandled by the Europol, advising Europol on all matters concerning the processing of personal data, and finally, by preparing an inspection to be carried out by us in cooperation with national data protection authorities in December. And then I can tell you more in details by speaking first about our vision of what data protection in practice should be in The Hague, which is 3 hours distant from us in Brussels, and second about ground control in Rue Montoyer, my office here in Brussels. So you may say, but how you envisage, how you perform supervision in practice? I would be very pleased to exchange some views with you on data protection, to listen to your views and reply to your questions if any. I will very, very briefly only focus on 3 key elements, and apologies for, let's say, a data protection jargon. The first element is accountability. Europol is now, by a data protection viewpoint, fully accountable and fully transparent and as internal organization. And therefore we will rely as EDPS on the accountability principle. This principle is at the heart of the data protection reform to be applied to all member states and to all European Union institutions and bodies, also in the area of police and judicial cooperation. It means a risk-based approach. It means that Europol, as well as other data controllers, should provide for a reasonable level of proper documentation of the data processing activities performed by the organization, and this aims at facilitating control on policies, data flows. It means IT tools integrated also by the local data protection officer and the supervisory authority in charge. But it also requires a first risk assessment. They need to better identify, address and monitor the risk for the data subject. They need to go deeper in terms of data protection impact assessment, where they need to consult where appropriate the supervisory authority prior to starting processing operations which are considered to be particularly risky for the rights and freedoms of the individual concerned. We at the DPS consider that these basic steps fully apply to Europol, and we are working together with the Europol Data Protection Officer and Europol as an organization to effectively implement this approach. And let me point out the role of the local data protection officer, which is named at Europol Data Protection Function. This is a key element to help identifying risks and should therefore be closely involved by the management in any new project to ensure data protection by design and assist in the performance of data protection impact assessment. The data protection function is also our first and citizens' first and main point of contact, and therefore they know what's happening at Europol. They are experts on data protection. They are the optimal interface between us and Europol. Be reassured that we are on the right track in terms of cooperation with national DPAs, bilaterally, for instance, when we have to deal with complaints, or multilaterally through the cooperation board I already mentioned. We already organized the second meeting, which will take place on the 16th of November, and the first meeting we had the chance to immediately elect the new management and adopt our rules of procedure. And this spirit of genuine cooperation is also reflected in additional actions, including the first inspection, which is planned for next week. So we are working in a nutshell, in continuity with the past supervision, but we're also developing an entirely new and tailor-made supervision policy. We would like to better consider the challenges of the new legal framework under the data protection viewpoint. We understand that the need for Europol to rapidly adapt and be at the forefront of the technological innovation, and therefore we must be all aware about the fact that also criminality takes advantage of always new and more powerful IT tools, and therefore also the law enforcement bodies such as Europol should therefore be able to master such tools. But at the same time, the protection of individuals should be technologically neutral and not depend or suffer from the techniques used. And therefore, we would like to give a practical answer to a specific question. What does it mean at Europol compliance with the necessity and proportionality? What does it mean processing personal data fairly and lawfully by law enforcement bodies? So it's a challenging task which requires also data qualities reviews and audits where appropriate. So let me finally recall what we did in the last year, in the last 5 months. Our Europol supervision team is composed by not only a head of activity, but also by legal officers and IT officers. We have introduced a practice to have bi-monthlies, meaning that our team meets regularly with the data protection function unit at Europol, and also other operational Europol staff on, in particular, new projects and also other previously agreed issues. 2 meetings so far, 10th of July, 25th of September, other are planned. We got in 5 months 2 complaints so far. One inadmissible, the other is pending, and therefore we consulted the concerned National Data Protection Authority. The response is pending with that authority. But the most important activity from our side relates to the opinion we adopted on the Europol Integrated Data Management Concept Guidelines. This is one of the pillars for the processing of personal data in practice at the Europol. We provided comments on the first draft adopted by the management board, and I had the pleasure to be invited last week at the first meeting right after our opinion of the management board, and we assume that they are working hard to satisfy our recommendations. To conclude, we are taking responsibility for the first and unprecedented application of the accountability principle in the area of freedom, security and justice. This is, dear President, a real novelty. And we are acting as a beacon of respect of fundamental rights and freedom. So we try to be in the avant-garde of the process of the effective implementation of this principle within the police and judicial activities, though in a tailor-made approach. So the protection of personal data is not the only element to consider about Europol, but is a structural part of the European Union legal system, and therefore we would like to continue working in terms of successful cooperation with you first, with all the other relevant institutions and competent authorities exactly for the protection on this value. Thank you for your attention.